So I want to move into today's activity. Chapters 3 and 4, we're going to be talking about the American judicial system. More specifically, though, we're going to talk about jurisdiction and resolving disputes. And then I do want to make you mindful of Socrative if you're interested in participating in that. All right. And the room is Prof. Blackmore. And you click join. All right. And so in this chapter, we've already discussed some of the introductory material about the courts and all those kinds of things. But what I want to make you aware of is that, you know, if you have a business dispute, and businesses do have disputes from one business to another, or where they may need to file a lawsuit, you just can't just say to yourself, oh, I passed by a courthouse the other day. I'm just going to take this lawsuit over there and I'm just going to file it over there. No. You have to file your case in the court that has jurisdiction. If the court does not have jurisdiction, it cannot help you. You can't take your case for breach of contract and you say, oh, look, I just passed by the criminal courthouse the other day. I'm just going to drop this off and file it over at the criminal courthouse. The criminal judge will have no jurisdiction over a civil breach of contract lawsuit. So it is very important that we talk about jurisdiction, and our book tells us that jurisdiction is a court's authority to decide a particular case based on who the parties are and the subject matter of their dispute. And then your book talks about venue, a determination of the most appropriate court location for litigating a dispute. Let's say we're here in California and you want to file a lawsuit against somebody, and that person lives in Santa Barbara. You're going to just go on down to the Los Angeles County Superior Court and file your paperwork at that court. That might be a good venue for you because your office is right around the corner, but the defendant lives in Santa Barbara. In most places, you have to file your case in the venue that is where the defendant is located. In most cases, you can do it and see if you can get away with it, but then expect that defendant to file a motion to transfer venue to the Santa Barbara County Superior Court. That's venue. It's still under the umbrella of the California Superior Court. California Superior Court has courts in Los Angeles County. They have courts in Santa Barbara County. They have courts in San Diego. They have courts in San Francisco. They have courts in Ventura County. They have millions of courts. And so this is the idea that describes venue. And so jurisdiction is a business strategy, and we're going to talk more about this as we go on today because the focus of our class is going to be talking about out-of-state defendants. And so most times a business, and this is one of the main reasons that a business will incorporate in the state of Nevada, so that they can always find themselves to be an out-of-state defendant. And we'll talk more about the reasons why. And then our book tells us jurisdiction requires a two-part analysis. Okay, a court must have both. Can't just have one. You gotta have both. Subject matter and personal jurisdiction. The subject matter jurisdiction in most state courts is not going to be the sticking point. Because if I go to any California Superior Court and I file a case for a breach of contract, Los Angeles County Superior Court, Ventura County Superior Court, I can file that case in any of those courts. It's not going to, it's going to be, but the personal jurisdiction piece may be the part that's going to cause the problem, and we'll look into that. And so this is straight from our book. Right there on page 83, gives you that two-part analysis. You have to have both subject matter and personal jurisdiction. And in some instances, you will see it called in personam jurisdiction. It means the same thing, personal jurisdiction. Now, this is more when you're getting into federal courts. Your book talked about state courts and federal courts, but this is more when you're going to go into a federal court. This is the only way you can get into a federal court on the subject matter jurisdiction prong of the test. Is either it's going to have to be a federal question, something dealing with like the Hulk Hogan case, something dealing with a constitutional right, something like that, or if it's not a federal question, anything dealing with the Constitution, or then you're going to have to establish that you have diversity of citizenship. We had this in a case. Can somebody remember which one it was?
It was a Chipotle case?
Yes, Chipotle. We had this in Chipotle. This is what you have to have. You have to have parties from two different states, and the amount of controversy has to exceed $75,000. If I come to the court and the parties are from two different states, but then I say in my pleadings that the amount in controversy is $50,000, we're not going to have diversity of citizenship, and you better have a federal question, otherwise you're going to get knocked out of that court. You're going to get knocked out of that court because the court can only hear your matter if it has jurisdiction. It has to meet the two prongs, one of which is subject matter jurisdiction. If your amount of controversy is only $50,000, you're not going to have diversity of citizenship. You better have some type of federal question. Otherwise, you don't meet subject matter jurisdiction. We have to have subject matter and personal. And so our book tells us again about how this is called in personam jurisdiction. It talks about the in-state versus the out-of-state defendants, the state loan Arm Statute, minimum contacts. This is what we're going to talk about today, because it'll be better for me just to talk about it in this way. And so now that we know that we have to have the subject matter and the personal jurisdiction, well then now our book talks about a two-pronged test to determine whether it has personal jurisdiction over a party who does not reside in the state. We need to know that. Why? Because if I'm in the state of California and I'm bringing suit against somebody from out of state, I might not have jurisdiction. I mean, usually, we're all here together. The court's going to have jurisdiction over us. But if you have never, ever been to the state of California, the court's going to be like, wait a minute now. This might not comport with due process, with the defendant's due process. Because remember I was telling you about venue, you can't, you can, and we do it all the time, file lawsuits, to recoup money in business, when there's a business loss. You'll file a lawsuit against a person. And we're right here in Los Angeles, downtown Los Angeles. We're always going to file that right down there at Stanley Moss Courthouse on Hill Street. Because that's what, right there. And then if the defendant wants to file, and if the defendant lives in Santa Barbara, well, that defendant's going to have to travel all the way from Santa Barbara to Los Angeles to do depositions. That's not going to comport with the defendant's due process. I'm bringing a lawsuit against you. it would not necessarily be right for me to say that you have to come all the way from San Diego to a deposition in my office here. And there are other things, that person will have to come all the way to Los Angeles if the case goes to trial, or motions or hearings and these types of things. And so in that same respect for jurisdiction, you have a person in Pennsylvania, a company in Pennsylvania, they have to come all the way to California to litigate that lawsuit. So that's going to be a stopping point. And so there is a test that your book talks about that a court will look at before they decide whether or not it has jurisdiction, because the court is going to have subject matter and personal jurisdiction. Now we're talking about personal jurisdiction, and the first step is that the state is going to have some type of a long arm statute. And then the second part of that test is that the court is going to want to ensure that exercising jurisdiction over that out-of-state defendant meets the constitutional requirements of fairness and due process. And then our book tells us, they drill down even more, and they say, oh, how are you going to find out if there's fairness and due process? Here are two questions that we ask. There has to be some level of minimum context. And then the court's going to ask, did that defendant purposely avail itself to the forum state? That's a term of art. They call it the forum state, California, which is where the business took place. And so here we have our two-pronged test. You're going to have your state long-arm statute. This is for personal jurisdiction on an out-of-state defendant. And you have to have your fairness and due process. How do we determine fairness and due process? Minimum context and purposeful availment. I showed you that page from the book because I didn't want you to think I made that up. That came straight from the book. And then your book gives you some information about the long arm statute. And so today, we're going to talk about this case, Transamerican Power Products Incorporated versus American High Mast LLC. And I want to go back to Miss Carol, because you were asking me in the last class about clerkships. You saw something, and I failed to talk to you. I just talked about judicial clerkships, but there are law firms they hire clerks. I don't like to do it because you don't pay them. They're just getting experience. You know what I mean? And I just
they don't get paid anything?
No, not generally in a law firm. No. Now judicial clerks, they do. If they're out of law school, they'll get paid. But if you're doing a clerkship while you're in law school, it's like a part of you'll get credit for that. It's like an internship. Is what it is. And I remember this case because when I was in law school, I did a clerkship with this law firm, and then after the attorney hired me, Mr. Magenheim, Alan Magenheim. He's a big-time lawyer. He is a big-time lawyer in Houston, Texas. And we had this case, and I had to do briefing on this case. I remember this case very well. And we represented Transamerican Power Products Incorporated. And so I am looking for someone today who is going to be the owner of Transamerican Power Products. I need a volunteer. Thank you. Okay, so I'm going to give you your last name. Mr. Coker. And then, I really want to make this interesting. I want you to go head-to-head with this person today. So I'm also going to be looking for a owner of American High Mast. Come on. Thank you. Okay. sure you want to be here on record? Okay. Okay, so this is our case. And I want to show you this map. So this is your 10th Circuit. It's not just California. It's all of these states. Okay, but today we're going to be over here in the 5th Circuit Court of Appeals. Because this case that I'm talking to you about is a case from back when I was a young, I'm talking about fresh out of law school. I'm going to tell you how fresh I was in a few minutes out of law school. And when I read some of the information, I was like, dang, I went in on the arguments. I mean, I just really did. Because this lawyer, now you were talking to me about litigation. And see, now this is a law firm, the way it's set up. Mr. Magenheim, he was a kingpin. He was the mob father. We all had to kiss his ring. We all worked for him. His name went on everything. Okay? And we had like 10, 20 of us. We did all of the research, the work, and we did it all. Then we just take it in there, he signs it, and we file it with the court. Okay? And so these are all of your circuits. You have your DC, you have your federal. It would be nice if they put a little number over there, huh? Let me put a number. Okay. So here's the case. I just wrote this little article about this thing and published it in the Houston Lawyer. 2003. So that's like a long time ago. And so here are our facts right here. I'm just supposing for you because it was hard for me to dig up because that's in the olden days. They didn't keep things so much so like they do today. I can find all of the case documents online with the courthouse. And so here are our facts. You have a client who is a Texas resident in the business of manufacturing a product made specifically for its non-resident customer and according to the non-resident customer specification, the power poles. And we'll get more into the facts. The non-resident customer may never physically enter the state of Texas as the parties transact their business via telephone, fax, email, etc. Did you have a question? Your client's dealings with this non-resident customer spans a number of years and has involved various contracts. A non-resident customer initiates each transaction with your client by faxing or emailing a price quote, providing relevant specification and drawings to your client. Your client then sends the non-resident customer a price quotation based on this specification. Your client's operations are headquartered in Texas, and most of the manufacturing process occurs in Texas. And then I just put here, it would be nice if they had contracts where they would have what we call a choice of law clause, because if you have a choice of law clause in that contract, then it'll decide what state's law governs if there's ever a dispute between the parties. But sometimes customers, they like just a handshake feel of doing things. They don't want to scare anybody off. When you start talking about clauses and contracts, people might back up and go find somebody else. And so they didn't do that. They had this price quote thing that they did. There were no contracts. And so everything is progressing smoothly between the parties until American Mast decides they don't want to pay for the calls. Your client then brings suit in the state court for damages resulting from the breach of the contract. And then let me tell you what you do now. And I'm going to tell you why you're doing this.
Okay.
You do this because most state courts, judges, are elected officials. It's political. In the state of Texas, me as an attorney, I can go and pay up until, there are limits, but I can pay into the judge's campaign fund. And so I show up at the courthouse one day, and Ms. Lily May, who has paid $10,000 into the court's campaign fund, and I just paid my little $100. And we show up. I'm just saying, you would think that ethical concerns will kick in, and but it's just not like that. I'm sorry to say, it's just not like that. And sometimes, we have these laws. I know sometimes you hear about tort reform and all these kinds of things. More state court judges in more liberal locales are more, they will let you have a jury trial and just blow the thing out, millions of dollars. Well, most people would rather have a federal judge who has been appointed. He has no political ties to anybody. He's just more of a neutral party, just in the middle. He doesn't owe any, he doesn't have any, there's no campaign, there's no, and so people more so, defendants like to remove that state court case to a federal court. And so that's what your sneaky self did. You removed the case to federal court, and then let me tell you what you did. You filed a motion to dismiss for lack of personal jurisdiction. Why? Because you are an out-of-state defendant. And so I'm going to tell you that sometimes a business or a person's facts, a business or a person's attorney is better than their facts, because your facts are not great. But your attorneys, they really did their job. They really went in.
Why do they not want to pay for the telephone poles?
Okay, we don't get into all of that. Hold on, you always want to go before
I know, it's always the cart before the horse. I apologize.
Okay. So I just want to show you this. Somebody was asking me, yes, sir.
Sir, but what does removes the case mean?
That means we're in state court, and because I am an out-of-state defendant and I meet that, I think I meet the diversity test. When you have to have subject matter and personal, one of the ways you can have personal jurisdiction in that federal court is by a federal question. I'm sorry, the subject matter jurisdiction is by a federal question or by diversity.
So, the client initially filed their suit in their own state's court?
So, yes, you did, Mr. Transamerican Power Products. You filed because American High Mast did not pay you. We're going to get into the reasons why. But after you kept asking her to pay you, you said, okay, I'm going to take you right over here to the little state court over here by my, it's right here in my neighborhood, and I'm going to sue you for breach of contract. Okay? And so, that's great for you. But she says, oh, you know what? Mr. Magenheim is so well known in that court. And I don't want to get caught up in all of the political leanings of the fact that the judge likes Mr. Magenheim or whatever the case may be, or I really want to just put a wrinkle in your plan. I'm going to, because I can, because I meet that subject matter test of having the two people from two different states and the amount of controversy of more than $75,000. I'm going to remove this to a better court for myself, where I think I'm going to do better. And then once I get there, I'm going to file a motion to dismiss because the court lacks personal jurisdiction over me because I'm way in this other state. And so let me just go back. Because this is the part that I missed telling you about. Here's Transamerican Power Products. We already know that they're in Houston, Texas. And you have this nice website, Mr. Colbert. I really love it. Look at all, it's just beautiful. Look at all the kinds of things. Let's see here.
Yeah, that's me right there.
This is you. That's not you. Okay, But these are all different kinds of things. Look, lighting poles, all kinds of poles. I'm gonna go over here and give you some equal time, Miss American High Mast. See, there are all kinds of poles. Poles that may be used on the highway lights. You just do all kinds of things. And so this company is from Pennsylvania. I mean, it's not a great website. Is this? I'm sorry. You don't have a great website. Okay, but it still gets the job done. Okay, that's all we need. And I think they do it for a reason this way, but anyway. And so somebody was asking me about, is there a demand? Look at all of these cases. These are all this is a list of, cases, even recent cases that Transamerican Power Products has had to file because, look, breach of contract, contract. Because they have lawyers who go after their payments. And so here is the lawsuit that you filed in Harris County. And here is the citation, because it's for procedure. You just can't go and say, hi, Ms. High Mast, here's your lawsuit. Thank you. I appreciate your business. No, you have to get a citation. You have to get the sheriff to go and serve that on the person for it to be proper notice. A person, if you're going to sue them, they have to have proper notice. And so courts have procedural ways of making sure that that is taken care of, because you just can't go to the judge and say, okay, judge, I want my judgment now. I let her know. I called her on the phone. I told her that I sued her. She hasn't showed up. I'm ready for my judgment. No. The way the court's going to know that you know is because the sheriff will have served this on you. And the sheriff, when he serves that thing, he's going to come down here and put, okay, I served him so-and-so, I gave it to so-and-so at such time. Then the sheriff is going to file that return with the court. Yes, sir.
So to be kind of specific, but does the sheriff in my state serve it, or the sheriff in their state serve it?
So there is a way to serve an out-of-state defendant. And so here is, and you, most of the time you do it because you'll serve the Secretary of State. And so that's what they did. They served the Secretary of State. So what happened is, if you're, most states, you kind of have to be registered with that state Secretary of State. It just depends on whatever the rules are for that state. But this particular state, you can serve through the Secretary of the State of Texas Citations Unit, and they will send this to the registered agent for this company. You have to go to the Pennsylvania Secretary of State's records and find out who the registered agent is. This company is registered with the Secretary of State for the state of Pennsylvania. So there's a way that I can go, I can find out who the registered agent, who the person is designated, who is to accept service of legal papers for that company. Once I find that out, I let the clerk know for this court, and I get a citation. The citation will be issued by the clerk, made to be served through the Secretary of State, and to be forwarded to the registered agent for that company. if there is no registered agent, in most cases, the president or a officer of the company can accept service. And so this is what we have. And so these are all the moving papers. And I'm gonna go here. And see, and so then you have your, just some brief background allegations. They talk about venue. We're all ready to do this in the state of Texas. So you have your breach of contract. Unjust enrichment, attorney's fees. And then, guess what? $111,313. Does that meet the test, Mr. Colbert, for your diversity? How much do you have to have?
75,000.
75,000. Do you meet it?
Am I diversity? Wouldn't that be?
Okay. Do you meet it? She meets it. And so then she removes it to the federal court. And then the only thing that you need to do is to file a notice of removal. You'll attach the plaintiff's petition to that. You'll want to, state the jurisdiction for the court so they will know, because there's certain things you have to do. You have to meet a certain time deadline. There's some procedure for the removal as well. And so then he talks about the $75,000 to let the court know that he meets that test. And so this is the federal court docket sheet now. Okay, so we can see how, you did your little notice of removal. And then right out of the box, you file your motion for motion to dismiss. I mean, you didn't waste any time doing that. I mean, you want to get rid of this thing right away. You know you didn't pay for them polls, but that's not what we're talking about all that later. So I don't have all of these documents, but I was able to scrounge up a copy of, because you file the motion, then you file the opposition, then they file a reply, then you file a response to the reply, and so I was able to find all of that. And here is the reply. And so then I showed you the circuit map because, see, now what you're going to have to do is you're going to have to, we have our prongs of our test. And to be able to establish the due process portion of that, we got to have the minimum contacts. Okay. Well, remember how I told you, you just can't just say, oh, all right, hi, judge, minimum contacts are established. No. The common law is provided a case. The court has already interpreted what will need to be in place for you to establish that minimum contacts in the Fifth Circuit. And so somebody asked me, they said, do attorneys have to use cases from their own state? Does California have to use California cases for president, etc.? Yes. In California, the California judge does not want to hear about a Texas case. So the California judge is going to want to hear about California cases or cases from the Ninth Circuit Court of Appeals, cases from California state courts, cases from California Courts of Appeals, or cases from the Ninth Circuit Federal District Courts or the Ninth Circuit Court of Appeals. That's what a California judge is going to want to see. And so I'm going to go straight there. I'm already in the federal court, so the federal judge is going to want to know what the law is in the Fifth Circuit. This judge in the federal court in Houston, Texas, the Southern District, the United States District Court for the Southern District of Texas, could care less about a case from the Ninth Circuit Court of Appeals. I have to tell this judge how minimum contacts are established in the Fifth Circuit, in the jurisdiction where the court is sitting. And so you have your little, you got your A, B, C, you gotta have all of these, and D. So you gotta have all shipments are initiated by the defendant. The task of directing the details of such shipments were ones which the defendant exercised a significant measure of control. A relationship between the parties is sustained arising out of multiple dealings, not a single or fortuitous contract. And D, plaintiff performed its part of the undertaking at its place of business in the foreign state. And this is known to the defendant. This is what you're going to have. And so we go through the allegations here. And so American High Mast says that the emails and the correspondence were not price quotations. And so this is what I said. I said, however, each communication from the defendant in Exhibit D, I don't have the exhibit, it's a specific request from Miss American High Mast that plaintiff provide her with a price proposed based on, I mean, you had the write-up. You said, this is what I need to be this tall and all this. Tell me how much it's going to cost for you to do that. How you going to now say these are not price quotations? You said that. Okay. And so, I mean, I have your price
I thought you
quotation.
said my lawyer was smart.
Well, that's why I said your lawyer was better than your facts.
Oh, I got it, okay.
Yeah. They had to do what they did. They said, oh no, don't look at this, judge. These are not price quotations. They may look like price, but there's
These aren't the
nothing
first
here.
you're looking for.
Yeah.
Okay.
Okay, so, and then they contend that they did not, okay, so what they're saying is that we didn't initiate anything with you. For whatever reason, you just sent me this, and they're not price quotations, and just a little note from you. And then it says, defendant contends that it did not direct or supervise the actual fabrication or manufacture of the product made the basis of this suit. Well, that's craziness. But then what I do is I go and I find a case that deals with that. I say, in this case, the non-resident defendant purportedly placed orders for providing proofs to the plaintiff in order to facilitate the manufacturing process from which the non-resident defendant expected to profit. And then I go and I tell the judge, okay, where it went on the page where you can find it. And he goes and he reads that and he is satisfied with that. Plaintiff asserts that defendant facilitated the manufacturing process, providing specifications and drawings for the plaintiff to manufacture the poles. And the defendant specified where and how he wanted the plaintiff to deliver the product. I mean, we're talking about, you can't take this thing here and I just send it to you, and then you send it to where you want. I mean, it's a huge thing. You tell me where you want me to send it to be installed. So how can you say that you didn't direct or facilitate this process? Defendant contends that Transamerican's company ledger information attached is not sufficient to show the various contracts entered into between the plaintiff and the defendant. The plaintiff asserts that the defendant admitted in his response that there were at least 7 contracts. Okay, lawyers. They're okay lawyers. They admitted that. And the ledgers were provided for this purpose, to support its assertion of minimum contacts based on the multiple dealings between the parties. Not necessarily to assert that a contract had been entered into, but just to show that there was not just this fortuitous communication between the parties. And so, further, plaintiff reiterates that the Fifth Circuit has stated that even a single substantial act directed toward the forum can support specific jurisdiction if that act gave rise to the claim being asserted. And so then I cite my case. And the defendant contends that the product manufactured by the plaintiff is not manufactured in Texas. Transamerican power products, part of the poles are manufactured in Mexico. They're sent then to the headquarters office in Houston, and then they do some, I don't know what this means, they galvanize them in Houston. And then they deliver them to the final point of contact. Huh?
We finally galvanized with Galveston.
And then I also talk about the long arm statute, because remember that's one prong of it, of the test. And that statute says that the Texas resident and either party is to perform the contract in whole or in part. That's coming straight from the long arm statute. Therefore, the product does not have to be wholly manufactured in the foreign state. Neither does the contract have to be fully performed in the foreign state. I mean, this is excellent work from an associate, a young attorney. When I read it, I just want to cry a tear. And then the request for price quotations, including specification, is sent to the plaintiff's headquarters in Houston. You're sending that to Houston. Okay, so, this defendant contends that it never took title of the product manufactured by the plaintiff. I love this part right here. It has nothing to do with anything, but I'm like, what prong does that go with? But what? You're telling me is to save you the inconvenience, I'm going to take this pole and take it to your final destination where you are going to do your business with whoever you're going to do your business with. I'm going to take it straight there for you. That's a part of the service that's being provided. And then you want to use that against me? I said, however, due to the trade custom, defendant would never gain actual physical possession of the product manufactured by the defendant, because the defendant always delivers the manufactured product to the location where it will ultimately be installed, instead of shipping the poles to the defendant, who would then be responsible for shipping the poles again to the customer's installation site. So that's just a example of how, and all of the things that a business has to be thinking about when they are encountered with a lawsuit, or when they're going to file a lawsuit. These are all considerations that they need to be mindful of. This is the long arm statute here. And it's codified right there. And even though it's codified, you see how I had to have the case that interprets what it means. That's how the law is. That's why I talked to you about the common law. Nobody, I could take this into the court all day and night and say, hey, judge, let me just read this nice statute to you. Care less. I need to have a case from the Fifth Circuit that interprets the meaning of this, which is the common law. And so here is the judge's order. And really and truly, I made it really easy for him because he just regurgitated everything that I put in there. That statute that interprets minimum contacts for the Fifth Circuit is called a no mere passive customer. And they're saying we're just a passive customer, meaning I could sell you stuff all day over the internet. If I never step foot into the state of Texas, I'm just and as I say, I just sold you one iPhone. I'm just a mere passive customer. So the court is not probably going to have personal jurisdiction over me. And so that is what that means. In the end, the court denied American High Mast motion. And guess what happened? After your motion was denied, what do you think you did? Appealed? You said, okay, Mr. Transamerican, let me go ahead and settle this case.
Oh, you settled? I want to know how many polls it was. I mean,
Oh,
what was the
gosh,
poll?
I can't remember.
How many polls was that?
No.
One?
Well, we're not
And all
talking
the
about,
manufacturing costs?
well, come on, we're not talking about a little pole like your pen that you're writing with. We're talking about a huge, did you see that? Those things? Like when you're riding down the 101, the light poles?
Oh, no, I get it.
Yeah.
I just.
It might have been like 2 or 3 poles.
Yeah.
But at any rate, the case was dismissed on the settlement of the party.
But I do have a question.
Yes, ma'am.
Why, I mean, this is probably a hypothetical because I don't think anybody's going to be able to answer. After years of contracting with this person, why would they not pay?
Okay, I'm sorry. You go back.
If you're a contractor and you have to get something in by a specific time and you don't for whatever reason, and like your contract goes over the amount of days and suddenly you're being charged like liquidated damages, you're gonna want to make up for that by, you know, maybe not paying a vendor here or something like that.
Okay.
And the
You-
contractor's perspective.
You mean American High Mast?
Yeah.
Okay.
See why they would try not to pay.
Okay. But when you went to Miss American High Mast and said, okay, I need you to pay me. Y'all couldn't work something out? You're just gonna say, I'm not gonna pay you at all? We have a product that's manufactured in Mexico, a huge pole, that's then having to be delivered to the Houston office to be galvanized. And you don't wanna pay anything?
They sent it to New Hampshire, right?
Huh?
No, they had to send it to New Hampshire.
Well, in this
Oh,
case,
Pennsylvania.
well, no, I don't know where they were
No?
sending it. Actually, no, because they don't, even though you're in Pennsylvania,
That's right.
Right.
We're in Pennsylvania,
yeah,
but
So
I don't know
where it landed could have been anywhere.
yeah. And I don't know where that was. I can't remember what that was for this particular case. So,
But even if they were late though, if I have like you were saying, like if I'm making a product or I'm having a product made, it really don't matter. And that product is made to order. It's like if you make a yacht, you know.
Right.
If I go, I'm 3/4 of the way done building your yacht.
Right.
and you decide that you want to change up the specifications, and you send me
Right.
a plan that means I gotta, cut the whole part off of it and build another part, that's going to continue to take longer. You can't say, okay, you still gotta have this done by this deadline.
Yes, that is. If I remember correctly, there was some specification after American High Mast had talked to their customer. There was some change up, a little change. So that change is going to have to be made in Mexico. That's going to delay that product getting to Houston to be galvanized. I believe that's what happened. I don't believe they just said, "Ooh, we late." I think it was they had a good reason. Yes, sir.
So, if they reached like a settlement at the end of the case, do you think that American High Mast had to pay like all the legal fees involved with this whole thing? Or
Well,
is that
just-
kind of up to the settlement?
Well, hold on. I don't know why I
You
need
can
to be
actually
here.
ask
You all
for-
always get ahead of me. You know what I'm going to do? I'm going to go
Ask
through
for
these
that,
pieces.
But I'm not sure.
Like in the
Is
settlement?
that in the next chapter?
No, that's in chapter 4. That's how these conglomerate. This is the dispute settlement. These are all the things that you need to keep in mind. When he first comes to you and says, "Okay, hello," you need to say to yourself, "Okay, what's going to happen if he sues me?" So that is a part. And so in most states, back before the lawsuit was filed, some states will require that you actually do that, and that you actually put a paragraph in your complaint that certifies that the parties have met and that they could not work it out.
Arbitration?
Well, now arbitration is something different, okay?
Yeah, but
see-
most companies, when doing business, state that you have to sign an agreement to go to
Right,
arbitration.
and there was no arbitration, there was no agreement at all here. All they had was price quotes. If they had an agreement, they could have put a choice of law clause in there, in the agreement. But there was no agreement at all. So arbitration is not gonna be a factor for this particular case, but that is what companies do to protect themselves. Mr. Transamerican? Right on the bottom of that price quote, you might want to have a little something scribbled under there. And so these are just some things that are talked about in your chapter 4. And so this is exactly what we did, the motion stage of this process. And so this is a consideration for getting the case ready to settle sometimes, depending on how it goes. And so these are some of our motions that I talked about, and this is the one that we filed in this particular case. And then this is the arbitration, but arbitration is a tricky thing. I mean, arbitration means we have an agreement to arbitrate. That means there's not going to be a lawsuit. That means you agree not to sue me. In lieu thereof, we're going to go to arbitration. That's arbitration, which is supposed to be more cost effective. And then you have your mediation. We do mediation sometimes, after. In this particular case, you'll see on the docket sheet that at some point the judge would have ordered these parties after that motion, if the motion was granted or whatever the case may be. Since the motion was denied, the case goes on. That case is going to go on before we get to a trial. The judge is going to order those parties to go to mediation to try to settle that case.
So I have a question,
Uh-huh.
and I don't know, but do you think that most business law cases, in the case of this one, I think that the buyer should have done their due diligence when the changes came through and stated that if we make these changes this late in the game, we have to have a different deadline date
I'm sure they did.
for that product.
I'm sure they did. And you didn't say, okay, well, that's all right. See, at this point, but I believe if I cannot really remember correctly, but I believe at this point what happened was the process had already, they made a change in the specification, but the poles had already been cut.
Right.
Right.
No, but what
It
I'm
was too
saying
late.
is if the person ordering the poles
Mm-hmm.
was to talk to the buyer should have told the person buying the poles that this late stage with the changing is going to delay it. And then when they talk to those guys, the manufacturers of it, they should have stated, okay, we had a due date of this, how much longer is it going to take?
I'm sure they did, but it was the cart was already out the gate by that time. The pole was already cut.
But
I'm sure
they
told.
said that they couldn't deliver on the date, that's why they didn't do it.
Right, but I'm
I'm
saying
stating that
I'm saying no, because what I'm saying is that they did a price quotation. They said, hey, we'll do it for this much. Somewhere along the way in the process, they wanted to change the specifications, and then that caused them to have to make a change up in Mexico of actually manufacturing the product after it probably had already gotten a long way in the stage where it was already a pole to their specifications.
The wrong specifications.
Well, it might have been a slight difference, or
the
the
first-
hole,
the
they
first
needed
set
6
of
holes
specs.
instead of 5 holes. Whatever the case may be, yeah, I believe it was a situation of that magnitude, yes
And
ma'am.
there was not a formal contract, right? It was just that, this is the price, okay, cool, let's do it, right?
Right, they would just send an email, they would say, hey, this is what I need, this is the tall, this is the I need 5 holes, blah, blah. Then, come to find out, American High Mast customer says, oh no, we're gonna really need 6 holes. They call back, the pole is already on its way out the door to Houston. And they say to them, hey, this is gonna be a delay, and they probably say, okay, well, get it as quick as you can. By the time they get it and it doesn't make it, they say, okay, we're not gonna pay for this. Yes, sir.
I was just curious, a lot of what we're talking about is like getting quotes, getting prices, which would be like a different thing than doing like a purchase order. And I guess when they said that they wanted it to be delivered to a certain location, that would kind of be more like a purchase order. But is that still just a quotation? Like, is it still in the what if area of like, what if you could make this product, how much would that cost, and could you do it by this time? Like, does that necessarily mean do that? Like, let's
Yes.
argue that they didn't initiate it.
Yes, oh yes, I think at some point it was consummated. I think they had a process where they do the price quote, then they send the price quotation, they say, okay, that's good, go for it. We need it by such date. We need to be done by this date, and we need to be sent here.
So at some point in time,
That's it.
the directions were sent, which confirmed that the quote then became a purchase order.
Right. Yes. A contract, an unwritten contract, yes ma'am, yes, yes sir.
When you say unwritten, like at this point in time with emails, was it considered that like emails are contractual?
Yes, I mean, you can, that's exactly what happened here, is that these writings made the basis of the parties' contract, but it was not a formal contract.
So they had formal contracts before. They had actual contracts.
They never had formal contracts. This is how they did, they called them contracts.
Oh, so every time with the emails, when
Right.
they're saying 7 contracts.
Yeah,
Oh.
this is how they always did business. And people do this. This is how you get in trouble. Okay, so do you agree with High Mast argument that the court lacked personal jurisdiction because it was an out-of-state defendant and did not have sufficient minimum contacts? Or Transamerican Power Products? And then that's going to be your next one, but let me see what you say on this one. Yes. Okay. There's always somebody who. Okay. All right, what about this one? Do you agree with the out-of-state defendant, American High Mast decision to settle the case after the court denied its motion to dismiss for lack of personal jurisdiction? Okay, all right. What about this one? Got one more for you. And this is going to answer both of your questions. Do you think American High Mast paid more or less money to resolve the case with Transamerican?
So you mean like more than what it costs for the initial?
More than the $111,000 that they would have paid. And quite frankly, this is what I would have advised you. I would say, okay, I would say, ma'am, the cost is $111,000. We were late. We'll accept $80,000. But what you ended up having to pay somebody said D. Okay, what was A? More money. You're gonna make so you need to think about that. First of all, you had bad facts. I assume your lawyer must have told you that you had bad facts.
Obviously, he didn't.
Oh, okay. All right. So, are there any questions about that? Any questions at all about this? I'm gonna.
So did they end up having to do what?
Yeah.
That's how it
Much
I don't-
more.
I'm not quite sure, but because I don't see, I know that I know that Mr. Magenheim would have settled that case for at least $111,000 plus attorney's fees and costs.
And then you have to understand all of those motions.
But
Cost the company.
you have to understand, she had to pay her attorneys
Yeah.
a lot of money. Okay. So if there are no further questions, if you could please turn in your exit ticket. Thank you.